This is Zebra Family Channel. Good morning and good afternoon and good evening wherever you are around the world. Have you subscribed in our channel? If not, what are you waiting for? Please like, share and subscribe.
I just have a question. Captain, I do not know what happened in the US. I wasn't there. You were there. My question might seem very simple to you. But this extradition hearing, did it happen in an open court? Did it happen behind closed doors on the papers only? How did it happen?
Well, according to my information, it's only based on the paper submissions that was made by the US part.
There was not a magistrate or a judge sitting on a bench.
Well, I think there was a judge. I'm not exactly sure of the process, but there should be a judge making.
You were not present.
No, I wasn't.
Yes. Now tell me, when you say the mention of a Kenya connection and so forth did not form part of the extradition application. What do you mean by that?
That is a mere fact when we followed up, my lord, on movements.
Yes, but was it placed before the court, before the judge? Was it mentioned to him?
Not to my knowledge. Only the facts in the case was mentioned.
Who appeared for the South African government in those proceedings?
That will be the US, the DOJ, Department of Justice, that side.
There was nobody from South Africa there. And as far as you know, the papers that were submitted to the magistrate or the judge, was there any reference in those papers that is now coming from the South African side? Were there any reference in those papers to Ms. CHOLOTA having connections or family or whatever in Kenya?
Well, I will lie if I say yes. I can't recall.
You cannot recall.
I cannot recall if that was part of that. I think not, but I cannot say for certain, unfortunately.
Was there any allegations before the US court coming from South Africa that she was a fugitive from justice?
Not directly, no. It's only basically the facts that were said before them, stating the procedures we followed to get it. The fugitive status for them, no. I can't recall that was addressed to them itself.
And had you informed Ms. CHOLOTA that this interview was to take place, or that you were on the way, or that you would come at a specific time? Was there any information that was relayed to her on that score?
No, not prior.
And so are we correct to then say that the FBI agents, together with the policemen from the Hawks, were at her home unannounced?
Yes.
Are we also correct to say that the interview took place without prior preparation on her part and unannounced? And
Ms.
that...
Macapello, would you please be so kind to give me opportunity to
My
record
apologies,
what
my
you
lord.
are asking?
It's my excitement. My apologies, my lord.
It also excites me if you go that fast. Yes, thank you.
I repeat the question that the two agents, so the two policemen from the Hawks, together with the 3 FBI agents, Miss Bean included, attended to Ms. CHOLOTA's residence unannounced.
Yes.
And that the interview took place without any prior preparation or information about the interview to Ms. CHOLOTA from the state's investigators?
Yes.
Now, the paragraph that we've just read, it states that you informed that you had questions based on her statements and her testimony before the State Capture Commission. My Lord, I beg leave to hand up Ms. CHOLOTA's affidavit as handed into the State Capture Commission of Inquiry. Captain, I put it to you that if a witness makes reference to the presidency and then the presidency means the office of the president. Is that correct?
That's correct, yes.
And that the two are not one and the same thing. Is that correct?
Most probably, yes.
And an instruction could come from the presidency but not be attributable to the president. Is that correct?
Could be.
Now, in her affidavit, Ms. CHOLOTA explained to the Zondo Commission and the chairperson of the Zondo Commission the makeup of the office of the Premier. Are you familiar with the makeup of the office of the Premier?
But I know there's a lot of personnel in this.
And so, if we are to accept that the office of the Premier and the Premier are two distinct entities, why is there a problem with her attributing an instruction to the office of the Premier?
But it doesn't say office of the Premier. It says Premier request.
Where does that state?
Where's the emails? Give me an email.
Are we referring to the email? This is a hypothetical situation that I'm putting to you.
I'm talking about facts. I want the email, then I will show you.
Okay. Can we go back to this, the two different entities? Thank you, my lord. I believe we were still busy with the office of the Premier and the Premier. Hypothetically, without sight of any emails, if there is an instruction that comes from the office of the Premier, does it necessarily follow that that instruction is from the Premier?
I didn't work on hypotheticals.
Then can we use the presidency as an example?
No.
Okay. Now, if we are to go back to the same HI, tab HI, again, the Constitutional Court affidavit. This is at page 8, paragraph 26. Page 8.
Is that the affidavit of Mr. Lord?
That would be your affidavit, Captain. HI, the plea.
No, sorry. Yes.
Paragraph 26.
Yes.
If you could please read that into the record for us.
Later that afternoon, Brigadier Gerber and I made a telephonic contact with the prosecutor in the Asbestos Project criminal matter after the Mason and informed him that in our view Mr. CHOLOTA was not very cooperative and had shown irritation and frustration at many of our questions, especially when she was pushed for more details or further answers.
And what does that mean, that cooperative, when used in this context?
You are reading from what paragraph?
26.
That would be tab HI, my lord.
Yes, that's page 8.
I think I'm pointing to a different issue. Before you right now, I'm questioning you on your own evidence that you wrote before the Constitutional Court. But I have the courtesy of putting the affidavit before you so that you can reference the affidavit when I ask you specific questions about specific paragraphs. If I were to ask you about page 18 of this affidavit without you having had sight of it, would it not be reasonable for you to be frustrated and irritated?
I just wouldn't be able to answer you if I don't have it in front of me.
Indeed. And would that make you not cooperative?
No, I won't say that.
Would it be reasonable for you to be frustrated at that? It would be unreasonable for you to be frustrated at that.
I won't be frustrated.
You would be
Asking for the document they're talking about.
because you feel
You're calm.
cool and calm. Thank you, my lord. If we can hold paragraph 26 and paragraph 31 on the following page, and I'm focusing there on the last sentences of both these paragraphs. Are you there? Hello?
Yes, I'm also there.
The end of paragraph 26, especially when she was pushed for more details or further answers, and the end of paragraph 31, and regularly became frustrated when we pressed her to provide facts which had to have been within her knowledge. Pushed and pressed. What does it look like for a witness to be pushed and pressed?
The same answer being asked over and over and over again. And not getting a response.
That would be pushing or the pressing.
Both.
So to push a witness is to ask the same question over and over and over again.
In different ways, yes.
And do you change your demeanor when you're pushing and pressing?
I have one demeanor.
Yes. And so in this instance, it would have been two of you having that demeanor, pushing and pressing.
I was conducting the interview.
And Brigadier Gerber,
Every now and then he would come in. But he wasn't the main person asking the questions.
he was simply there to intimidate. We will get to more affidavits where this pushing and pressing is mentioned, but for the purposes of this affidavit, could I simply ask, is this what is to be expected by witnesses, to be pushed and pressed? Or is it simply Ms. CHOLOTA?
We ask questions to each and every person who can assist in a criminal matter.
Are they also pushed?
Well, if you note, I do not interview the person. If most probably I do not know the answer already.
Interesting. Thank you, Captain. If we then have regard to the sequence of events, if I'm understanding it correctly, the 22nd was questioning, and the FBI officers were not in the room. It was the one FBI agent, two Hawks officials, and Ms. CHOLOTA. That was the first day of questioning, correct? And was there anything said to Ms. CHOLOTA regarding her uncooperativeness on that day?
Yes, I believe not the interview.
Could you take us into your confidence as to what was said to her?
Well, we gave her, as I said, we gave her basically advice. It would be in her best interest to seek legal advice. Because according to us, she's not giving her full cooperation, not answering the questions honestly. And we told her to get in contact with a legal representative of her choice to get some guidance. And if not, the same, or her demeanor are the same, we would not have any choice but to treat her as a suspect.
And did you tell the Constitutional Court of South Africa that in your affidavit? That you gave her, quote unquote, legal advice?
I don't give her legal advice.
Perhaps I've misunderstood you.
No. Legal advice is something else. I told her it would be in her interest to get legal advice.
My question still stands. Did you tell this, what you're telling this court, to the Constitutional Court?
That is my affidavit.
It's the one that would presently be sued.
Is it this one?
But on your preliminary glance of your affidavit, there's no way that you told the Constitutional Court what you were telling this court.
Well, that I'm told that it would be in their interest to
To
get
seek
legal
legal
advice.
advice.
No, on my first glance, no.
And did you tell the High Court this in the High Court affidavit, just off your own recollection, without having regard to your
I can't
affidavit?
recall.
You cannot recall. And what about the magistrate in the bail court? Did you tell her that you gave Ms. CHOLOTA advice to seek legal advice?
I don't know whether it came up, I can't remember.
If we turn to page 23 of the same affidavit under HI, page 23. Paragraph 86.6. We will be reading this into the record together with 86.9 on the following page. So that's 86.6 read together with 86.9. If you could please read those two paragraphs into the record, Captain.
Neither Brigadier Gerber nor I made any threats, admonished Mr. CHOLOTA, or intimidated her. It is correct, however, that we told Mr. CHOLOTA to think about the matter tonight, as a failure to cooperate may lead to us considering her to be a suspect. Statement 9.
86.9.
On the second day of the interview, it is correct that we informed Mr. CHOLOTA that a refusal to cooperate by answering the questions we posed to her would lead to her being considered a suspect and warned accordingly. There is nothing threatening encompassed in such a statement. The questions we asked of Mr. CHOLOTA were based on her own documents. There could not have been anything she honestly knew nothing of.
There is nothing threatening encompassed in such a statement. Threatening to whom? Or threatening according to whom?
Are we talking about now us warning her to be a suspect?
Yes, so it says that there's nothing threatening encompassed in such a statement. So warning her that her refusal to cooperate might lead to her being considered a suspect.
Well, it's not a threat, it's an actual fact.
Be that as it may, if someone tells me that they're going to punch me and they indeed punch me, that could also be argued as a threat, as a fact. But that's not what I think I'm getting at here. It says that there is nothing threatening encompassed in such a statement. Threatening according to whom? Yourself or Ms. CHOLOTA?
Well, to myself.
To myself. And on 86.6, neither Brigadier Gerber nor I made any threats, admonished Ms. CHOLOTA, or intimidated her. It is correct, however, it would be a qualifying statement to say, we don't deem that as threatening, but it is correct that we did tell her what we told her. Is that correct?
Well, we did tell her. I'm not denying it.
And so what would be the purpose of telling a witness to consider a matter overnight and then to attach the proviso that her failure to cooperate may lead to us considering her to be a suspect? What would be the purpose of that statement?
Being honest.
What was it trying to elicit from her?
No, nothing. It's plain. If the person for which I have evidence is implicit in a commission of a crime, and that person doesn't give cooperation, I have two choices. So I gave her the choice, then either work with us and tell us what she knows, or get advice and then we follow the other route, her being a suspect. So I basically gave her a decision.
And is this what the 90 witnesses in this matter can also expect? Being given this decision?
My Lord, if I may object at this junction with regard to the relevancies of the other 90 witnesses, we are dealing here specifically with issues of threatening of Ms. CHOLOTA. The other witnesses cannot go that far, my Lord. With all due respect.
I don't think you have to answer that question. You may proceed, ma'am.
Then let me put it like this. Is this how you normally treat witnesses that you interview? No,
No, it depends on the witness.
but this is not how you normally treat witnesses.
But all I can say is depending on the witness.
And in this particular instance, this treatment was sufficient for Ms. Cholota.
Well, she created the circumstances.
She created the circumstances. Thank you, Captain. Now, fortunately, you in fact did tell the Constitutional Court the reason that you actually charged Ms. Cholota. In your evidence of in chief, the state's legal representative questioned you about what do you say about the fact that Ace Makashule, the reason she was charged was because of Ace Makashule. And if I can just go to your response. It was that is not correct. That was your response, that is not correct, that she was charged because of Ace Makashule. Do I recall your examination in chief to be correct, that when you were asked that question, you responded that is not correct?
In what forum was that, ma'am?
It was his examination in chief, my lord. The
Where?
question here in this court, my lord.
Here in this court.
The question that was asked by my
Aye.
learned colleague for the state, that the defense alleges that the reason why Ms. Cholota was charged was because of Ace Makashule.
Oh, yes, I recall, yes.
Yes, thank you, my lord. To which he responded, that is not correct.
That is correct, yes.
Is that correct?
Yeah, so she wasn't charged because of Mr. Makashule.
Okay. Now, if we can please turn in the same affidavit to page 33, paragraph 133. If you could please read into the record paragraph 133.
The fact that Ms. Cholota did not contribute certain instructions to her former boss, and the result that she was then treated as a suspect in relation to some of the same charges Mr. Makashule, her former boss, was facing.
Now, Captain, the two statements are at odds with each other. It cannot be not correct that what the defense states is correct, and then this is what you stated at paragraph 133.
Can you just rephrase that question to make it clear?
There is a discrepancy
Yes.
between the statement that the captain made in evidence of chief, that it was not correct that Ms. Cholota was charged because she would not implicate Ace Makashule, and what the captain has stated at paragraph 133 of the Constitutional Court affidavit to which he deposed to.
Well, maybe then you can simply put it to the witness by saying that from this paragraph, for instance, it is clear that this is the only reason you decided to charge him.
Thank you, my lord. From this paragraph, it is clear that the reason that Ms. Cholota was charged was because she did not attribute certain instructions to her former boss. Is that correct?
Well, if you read that paragraph, it seems so.
Now, thank you for that, Captain. Now, if I were to ask, why is the consequence of her not cooperating fraud, corruption, and money laundering charges? Why was she not declared a hostile witness or brought to this court and declared a recalcitrant witness? Why is the consequence charges?
My Lord, I'm going to have to object at this stage, is that we are not in the process of needing evidence at this stage. We would not have those revenues available to us. There was no witness statement on which we could have even brought it before court to testify. This is what this issue is all about, my Lord, with all due respect.
My Lord, my learned colleague for the state unfortunately misunderstands my question. The consequence of Ms. CHOLOTA not cooperating, according to these facts and Kaptein's testimony, was charges. She was charged on money laundering, on corruption, and on fraud. The question is, why was that the consequence of not cooperating? That's the simple question.
The evidence was there.
The evidence was there.
Yes.
But when you questioned her, she was a witness.
Yeah.
But the evidence was there.
It's our decision how to handle the evidence.
And I'm glad you bring that up, Kaptein, because in the same Constitutional Court affidavit, you quote a case about reasonable and probable cause. If I can just find it. That would be at page 16, my lord, Kaptein. 16 of HI, the same affidavit. Paragraph 55. If you could please read that paragraph into the record.
National Director of Public Prosecutions, Mr. Zuma, 2009, SA 277, SCA. At paragraph 37, the Supreme Court of Appeal said as follows with regards to alleged political reasons for pursuing the prosecution. The prosecution is not wrongful merely because it is brought for an improper purpose. It will only be wrongful if, in addition, reasonable and probable grounds for prosecuting are absent, something not alleged by Mr. Zuma, and which in any event can only be determined once criminal proceedings have been concluded. The motive behind the prosecution is relevant because, as Schreitner J.A. said in connection with arrests, the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies for prosecutions.
Thank you, Kaptein. So if we stick to that last paragraph of this paragraph, it says the best motive does not cure an otherwise illegal arrest, and the worst motive does not render an otherwise legal arrest illegal. The same applies to prosecutions. What is your understanding of that? My Lord, it seems the senior counsel would like to have a word with the witness.
My junior admission should object. It's totally irrelevant what he's objecting. What's relevant is the court's opinion.
Yes, well, I would think that is anyway something for argument.
My Lord, if I may perhaps remind the state what the reason for our trial within a trial is. It is that at all parts of this extradition, unlawfulness was inherent in the manner in which the state operated. He has just stated to us that the reason she was charged was because she would not attribute those instructions to Mr. Mahashud. The paragraph he has just read says that that cannot be. There must be probable cause. And that is the only reason I'm putting this to this witness, because this is his affidavit and this is his own quotation.
Yes. Ms. Makopela, that may be so, but we must be mindful that, as far as I understand, this witness isn't a legal expert. He is not in the legal profession, so maybe it's unfair to read certain paragraphs to him coming from a judgment.
Thank you, my Lord.
What do you think about the judge, what he said about the extradition, what really happened in US? And what do you think about the lawyer of CHOLOTA? Because to me, this lawyer poked all the holes And it shows that all these things that Marshall has been saying, that this is a fabricated case against him, it's more political. Because when you listen to everything, while we are still on the trial within a trial, the holes that are being poked by the lawyer, Julius Captain, it was amazing to see how brave that lawyer was. Sometimes the people will be on stitches laughing in court because they couldn't hold themselves or what they were listening to. And this captain was so rude at times. But what I like about CHOLOTA lawyer, she was cool and calm and straight to the point. And what she did in court today, she has proved that she's matured and she knows her job. And she did a wonderful job in that court. What do you think, family? Drop your own comment. How do you see the case? Because I put only the important slides on this case. Not everything that is there, but I had to pick where the lawyer was so powerful and exposing this extradition that was done in the US of CHOLOTA. And the way everything was handled was really, really bad. What do you think, family? Drop your comment, like, share, and subscribe. And turn on our channel.